Ms. Norman, you have a case? Yes.
I think you have a Mr. Bell on your docket.
Yeah, Michael Lynn Bell.
Yes, he just spoke to me this morning. He's a former client, so if you can just give him a reset time to retain me, I'm gonna take over his case.
Okay, we're gonna have to give him, he's gonna have to fill out that judge's explanation of rights to defense without attorney, indicating that, he's gonna be hiring an attorney. It should be the, is it the first page on that clipboard? But he'll fill that out, but what I'm gonna go through, I'm gonna go ahead, this is random, I'll go ahead and random right quick.
Okay.
Shouldn't take. And then, Mr. Bean, Russell Bean, put your mic on mute, please. Thank you. Jefferson County Court at Law number 2 is now in session. The court is in session with the arraignment docket on today's date of July 23rd, 2024. Good morning, everyone. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. This morning, you have been asked to come to court for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies and misdemeanors. Case that you have in this court is a misdemeanor case because we handle misdemeanor cases. Your felony cases are your more serious type offenses, and your misdemeanor cases are referred to as your more petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And I'll use the term serious. What I'm talking about the facts of the case and the punishment range of the offense. Now, felonies are divided into 5 categories. We have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment minimum 6 months to a maximum of 2 years in the state jail. Person is convicted and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is a minimum of 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is a minimum of 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because, as I mentioned earlier, your case in this court is a misdemeanor case. Misdemeanors are divided into 3 categories. We'll start at the top and work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is fine only, and the fine is usually from $0 and it does not exceed $500. Now, the Class C misdemeanors are cases that are handled in the city court, which is the municipal court, or the JP court, which is the justice court. They come to this court only when the person appealed the case. They get convicted in the JP court or the city court, and then they file an appeal, and they appeal the case. And when they appeal the case comes to this court. Now, the punishment range does not change. It is still fine only. Now, if a person fails to pay the fine, or if the fine was converted to community service and they fail to perform the community service, then the court can issue what is called a capias pro fine. That simply means that is a warrant for the arrest of the person to either pay the fine or they would have to sit the fine out in jail. And if a person sits the fine out in jail, they will receive $100 per day that will be credited toward the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. And with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, a fine from $0 to $2,000, or a person could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, a fine from $0 to $4,000, or they could be given both such fine and confinement. Now, a person may be eligible for probation, and if they get probation, obviously they don't go to jail. They will serve out their jail time. It will be converted to probation. They'll be out on probation. There are 2 types of probations. One type of probation is called adjudicated probation, and the other type of probation is called unadjudicated probation. Now, with adjudicated probation, it just means that you have a conviction on your record. Now, if you successfully complete your probation, the court, there's something that's called judicial clemency, where the court can set aside the conviction. And in order to qualify for that, you would have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged from the probation. If those 3 things happen, then the court has the discretion to set aside the conviction, which is called judicial clemency, and you would not have a conviction on your record. Now, If you get a subsequent conviction, in essence, if you get another conviction later on, then the case that you received judicial clemency on can be brought back up. It could be revived, it could be resurrected, and it could be used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they could suspend or revoke your license. The other type of probation is called unadjudicated probation. With the unadjudicated probation, that means that you will not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. And what a non-disclosure is, it just basically means that your record is sealed to the general public. We cannot disclose the fact that you are on this deferred probation to the general public. Now, I use the term general public, and that is because the government can have access to it. But most of the public is general public, so most of the public will not have access to your criminal record if you have a non-disclosure. Now, as a defendant in a criminal case, you have rights. The first right that I'll talk about is your right to have an attorney. Now, on the clipboard that you have before you, there's a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And on that document, it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney to represent you, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. You must first fill out a financial affidavit. Now, the financial affidavit or the financial questionnaire is a document that is on the clipboard that is titled Jefferson County Affidavit of Indigence. It's a 3-page document. Jefferson County Affidavit of Indigence. You would have to fill out the first page and half of the second page, and then I will fill out the bottom of the second page and the third page. Now, if you want to represent yourself, you must first sign a written waiver to represent yourself. Now, the written waiver basically states that you are waiving your right to an attorney and you are wanting to represent yourself. The written waiver is titled Waiver of Counsel for purposes of entering guilty plea or proceeding in trial. It should be the document after the judge's explanation. Now, only ones who will sign that document is those people who will waive their right to an attorney and represent themselves. Now, if you waive your right to an attorney and you desire to represent yourself, you will have an opportunity to talk to one of the two assistant criminal district attorneys or the prosecutors who are sitting at the table before you. They work for the Jefferson County District Attorney's Office. You cannot speak to them unless you first sign a written waiver of your right to have an attorney to represent you. So at that point, you'll be representing yourself. You'll be your own lawyer, so you'll have a right to talk to them. Now, be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to waive your right to an attorney and you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of the document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, you'll see 5 lines to the left. If your choice is to hire your own attorney, you will place your initials on the first line to the left. If your choice, well, if you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to have an attorney, that is, you want to give up your right to have an attorney and you want to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line at the bottom of that document that is titled Defendant, and you will date it today's date, July 23rd of 2024. Do you understand? All right. Now, for those individuals who will be waiving their right to an attorney and representing themselves, you would have to read and sign the second document that is behind Judge's explanation, and that document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And that document states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, voluntarily means that no one is forcing you to do it, to enter into this waiver, and intelligent means that you know what you're doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 23rd day of July of 2024 by County Court at Law number 2 of Jefferson County, Texas, of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed to me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed to represent me. I hereby waive my right to counsel, and if that is your choice, then you will sign your name on the line that is titled Defendant, and you will date it today's date, and today's date is July 23rd of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. That area over there where you see those 12 chairs, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence. They will listen to all of the arguments. They will deliberate, and then they will decide whether to find you not guilty or guilty. You also have a right to waive or give up your right to have a jury trial. Waiving your right to have a jury trial means that you will not be having a jury trial. Now, if you waive your right to have a jury trial, your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. We call that a bench trial. A trial without a jury. It's just a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence, listen to all of the arguments, The judge will apply the facts to the law, and then the judge will decide to find you either not guilty or guilty. The other way that your case can come before the judge is by way of a plea bargain. A plea bargain is an agreement that you have reached with the state. So, for example, if you are representing yourself or you have an attorney that's representing you, and you or your attorney have negotiated with the district attorney's office to work out a settlement in your case, we call that a plea bargain agreement. Now, the second way that your case can come before the judge is by way of an unagreed plea bargain agreement. Unagreed plea bargain agreement means that you and the state, or you and your attorney and the state have not been able to reach a plea bargain agreement. And so therefore, you still would like to enter a plea on your case, but you want the judge to decide what the punishment will be. That will be an unagreed plea bargain agreement. Now, I've used the term plea. What that means is you could enter a plea, you could enter one of three pleas. You could enter a plea of not guilty. Not guilty means that you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or if you enter a plea of no contest, then you're telling the court that you will not be fighting or you will not be contesting the charges. Now, if you enter a plea of guilty or no contest, and your case will come before the judge by way of a plea bargain agreement. If you and your attorney have reached a plea bargain agreement with the state, we call that an agreed plea bargain agreement. Now, it comes before the judge. The judge can do one of two things. The judge could either accept or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, you have a right to take back or withdraw your plea of guilty or no contest. So, for example, let's say you and the state have worked out a plea bargain agreement, and the state says, well, judge, we're going to give Mr. John Doe probation, and the judge say, well, I'm going to reject that agreement. I'm not going to follow that agreement. Then Mr. John Doe can say, well, judge, I take back my plea of guilty and no contest. In essence, I'm not going forward with my plea. You can do that if the judge does not follow the plea bargain agreement that you have entered with the state. Now, if the judge follows the plea bargain agreement and within 30 days you decide, you know what, I would like to appeal my case. In essence, I would like a higher court to review my case to see whether or not I've been wrongfully convicted or whether or not the court committed an error by convicting me. Then if you would like to appeal your case and the judge has accepted or went along with the plea bargain agreement, you have to get permission from the judge who went along or accepted the plea bargain agreement. Now, if the judge gives you permission, your case will leave this court and go upstairs to the Ninth Court of Appeals. They will review your case to see whether or not you've been wrongfully convicted or whether or not the court committed an error. They can do one or two things with your case. They can grant your appeal or they can deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can send the case back down to this court or to this court to give you a whole new trial. Or they can deny your appeal. If they deny your appeal, at that point, you can appeal your case to a higher court than the Ninth Court of Appeals. You can file what is called a pro se petition for discretionary review, and I'll explain that to you. Pro se means that you'll be representing yourself. You will not have an attorney representing you. You'll be representing yourself. A petition for discretionary review, you'll be asking or petitioning the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. You'll be asking them to review your case to see whether or not your appeal should have been granted or whether or not this court wrongfully convicted you or whether or not this court committed an error by convicting you, then they can do one or two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if the Texas Court of Criminal Appeals deny your petition for discretionary review, at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. Witnesses sit in that chair with a microphone here, and what they will do, a witness can testify for you or against you. If you're representing yourself, you can ask them questions, or if you have an attorney representing you, your attorney can ask them questions. We call that either direct examination or cross-examination. You can also waive your right to have witnesses to come to court. Now, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses. Now, you also have a Fifth Amendment right against self-incrimination. I know sometimes, we watch television and we hear somebody in one of the criminal shows say, well, I take the Fifth. What that means is I'm not saying nothing. In essence, I have a Fifth Amendment right of the United States Constitution against self-incrimination, and I have a right to remain silent, and I will remain silent. So you have a Fifth Amendment right not to testify. So, and what that means is if you're in trial, the state of Texas, the government, the district attorney's office cannot call you as a witness in your case. Why? Because you have a Fifth Amendment right against self-incrimination. Now, you also have a right to waive or give up your Fifth Amendment right against self-incrimination. Now, if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be taking the witness stand to testify in your case. Now, you also have a right to have what we call discovery. And they use that word discovery. That's basically means you have a right to see the evidence that the state has against you, in essence, or to have access to the evidence that the state has against you. In essence, you have a right to discover what's in the state's file. So in essence, you have a right to see your statements, witness statements, police reports, lab reports, photos, audio recordings. You have a right to listen to audio recordings, see video recordings. You have a right to see any type of instruments that or documents that the state has and will be using against you in your case. You also have a right to waive or give up your right to have discovery as well. Now, everyone that's here for arraignment, you've been arrested and you're out of jail on bond. You're either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you may be out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here today in court. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say you and the state have reached a plea bargain agreement, and the plea bargain agreement is for you to serve 5 days in jail. Well, that means you won't have to serve any more time in jail because you already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. So you'll be what is called time served. Now, if the state is offering 7 days in jail and you spend 5 days in jail, that means you would only have to spend 2 days in jail because you already have 5 days credit. So we take 5 from 7, that leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. you will be credited $100 for every day that you spent in jail. So for example, if you're in the state and reached a plea bargaining agreement for you to pay $500 fine and court costs, well, that means you won't have to pay anything. Why? Because you spent 5 days in jail. That's $500. And so that $500 will be applied towards your fine and court costs. And so you won't have to pay anything. Your fine and court costs will be taxed and retired. Now, if the state is offering fine and court costs of $700, that means you only have to pay $200. Why? Because you already have $500 credit, and we're going to subtract the 500 from the 700, that leaves 200. Now, you'll be required to pay the 200 on the day that we dispose of the case. If you cannot pay the $200 on the day that we dispose of the case, no problem, because we could put you on what is called a payment plan. In essence, you can pay off in monthly installments, portion of what you're required to pay until it's all paid off. Now, some people may not have the ability to pay off the fine, even if they're put on a payment plan, no problem. Because at that point, we can convert the fine and court costs to community service. You will receive $12.50 credit toward your fine and court costs for every 1 hour of community service that you perform at a nonprofit organization in Southeast Texas or in the Jefferson County area. Now, if in the scenario that I just gave, it's a $200, if you owe $200, that simply means you would have to work 2 8-hour days, because 1 8-hour day is $100. So if you work 2 8-hour days, then that will pay off the balance of the $200. Now, Jefferson County has a program for people who have not been in trouble before. If it's your first time getting in trouble, Jefferson County or the district attorney's office has a program that is called pretrial diversion, where they will dismiss your case and you can get it expunged from your record. And the way it works is as follows. You'd have to get an attorney to help you fill out and submit the application to the district attorney's office. It cannot be an offense for resisting arrest or unlawfully carrying a weapon. And 2, it has to be your first time getting into trouble. If those things happen, as I mentioned earlier, you get into the program, they dismiss the case, you complete the program, you can get it wiped off your record. It's called expunge. You can get it expunged, deleted, erased, or wiped off from your criminal record. Now, if you're interested in that program, when we bring you up before us, you can tell us that and we can direct you to the people that you need to talk to. Jefferson County also has another program, which is part of the pretrial diversion program. It is called Veterans Court. Veterans Court is a program for veterans only. The only requirement is that you have to be a veteran of any one of the branches of the United States military. And in that program, with that program, you just have to be a veteran. You get into the program, they will dismiss, well, you get into the program and complete the program, they will dismiss the case and you could get a non-disclosure. A non-disclosure is what I mentioned earlier, where your record is sealed to the general public. Now, the government can have access to it, but the general public cannot have access. The only criteria or the requirement to get in that program is that you would have to be a veteran of any one of the branches of the United States military. Now, this court, County Court at Law number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office in March of 2017. With that program with that program, we have partnerships with agencies in our local community. One of the agencies that we have a partnership is the Spindletop program. Now, the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so to address that, we have the CSI program. And as I mentioned to you, we have a partnership with Spindletop Center. Spindletop Center is our local mental health center in Southeast Texas. Now with Spindletop has the ability to address your mental health needs. And the mental health needs, for example, in order to participate in the program, you do not have to be incompetent or insane. You could just merely suffer from anxiety or depression or any other host of mental illnesses. Spindletop has the knowledge and expertise to address your mental health needs. Now, Spindletop will, they can do a private interview in our conference room, or they can do it at their facility, or they can do it by phone, whichever is convenient for you. They can do an assessment and develop a treatment plan, either for outpatient or inpatient treatment. Spindletop also has a program that is called ATAR. It's an acronym that stands ATAR, that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR. OSAR is an acronym that stands, it's OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. So they have the ability to do screening and assessment and referrals for either outpatient or inpatient treatment. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. That's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once an individual is trained in any one of those areas that they select, they will help them to get a job in the area that they're trained in. If you have not graduated from high school and you do not have your GED, well, CICE also has a GED program. It's a graduate equivalency diploma program. With that program, you could get your high school equivalency diploma. Now, all of these programs that I just mentioned are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I say that when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community. Because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we'll have you talk to the right people that's here to get you to participate in any one of the programs that I just mentioned. Now, we have some folks here from Spindletop. They're going to come forward right now and tell you a little bit more about the program that Spindletop has to offer. We have Chloe and Deputy Hinton. They're going to come forward and tell you a little bit more about the Spindletop program.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the co-worker. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes to the event. The judge has found was that he's proved is those who have legal issues come to have. This lack of community resources to help.
Right here, we have a form that Steve passed out to each one of you guys. With this form, you'll be able to fill out the information. Once you fill this out, I'm the only person who receives this form. It serves basically as a baseline HIPAA consent form. So you're able to privately express any resources or assistance you need.
So maybe this is your first time to be in court, maybe it's your 10th time to be in court, there's still hope. In fact, what we're offering is that it has the ability to change your life, but it won't happen unless we get something from you with which you share that need with us. And on this document that Chloe spoke of, that was handed out in the first hand, you can express that need and we'll be able to help you with that and have it for you as well. Shortly, the court's going to go into recess. When it does, we'll be able to come out there and we'll visit with you. We'll pick up those documents from you and also have another card I'm going to give you that has a 1-800 number. We can give it to you so that simply we call that number. So when the court goes into recess, we'll be out there and we'll be able to again answer any questions you may. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Chloe. Now, ladies and gentlemen, I have some additional information that I need to give to you before we go into recess. The paperwork that you have in your hand, that's on the clipboard, we're going to pick that up from you. If you need help with filling the paperwork out, we have our core personnel who's here who will be happy to help you fill out the paperwork. Now, once the paperwork is filled out, we're going to pick that paperwork up. And then once we pick that paperwork up, we're going to go through the paperwork and then we're going to call you up before the bench one at a time. And then once we finish here at the bench, then you will go over to the court coordinator and then you may be given a reset date. Now, this is going to take us a little time to do. That is to pick the paperwork up from every individual, to assist individuals to fill out the paperwork and to evaluate the paperwork. Once that is done, then as I mentioned earlier, we'll be able to proceed. Now, this will take a little time. Now, if you need to use the restroom, there are 2 restrooms right outside in the hallway. They have the men's restroom, which is in front of County Court at Law number 3. And then on the opposite side of the hall, the women's restroom is in front of the 172nd District Court. You'll be allowed to go out in the halls to use the restroom. Now, do not leave the courthouse, because if you leave the courthouse and your name is called and you're not here, then your case can be, a warrant could be issued for your arrest. You'll be arrested at some point and then brought over to the Jefferson County Jail. So this process is just going to take us a couple of minutes to do. Just be patient with us. And at this time, now, if you have any questions, just let us know. As I mentioned earlier, we have some people who are here who'd be willing to help you. And you can just simply raise your hand and they'll come out and help you, assist you with filling out the paperwork. So at this time, the court will go into recess. Jefferson County Court at law number 2 is back in session with the arraignment docket on today's date of July 23rd, 2024. When I call your name, please come forward. This is cause number 24-CCCR 0994, cases style, the state of Texas versus Robert Johnson. Mr. Johnson, would you please come forward? Mr. Johnson, your full name is Robert Johnson?
Yes, sir.
Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson?
Good.
That's good. Mr. Johnson, I have before me a document that is titled Judge's Explanation of Rights Without an Attorney. Do you recognize this document?
Yes, sir.
And you have initials in 2 spots.
Yes, sir.
One of the spots you have initials stated that you've hired an attorney, in this case, Attorney Corey Crenshaw.
Yes, sir.
Is that correct?
Yes, sir.
Now, before you signed and initialed this document, did you read the documents?
I did.
Did you understand what you read?
Yes, I did.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay. Now, Mr. Johnson, your case is going to be reset by our court coordinator. Once your case is reset, you'll be free to go and you have a blessed day. You want to have a seat? Just have a seat on that first day. You're trying to see if,
He hasn't followed it. So.
okay. Just have a seat in that first chair on the wall. Next case is he's Mr. Russell Bean is no longer on Zoom. Okay. Next case is cause number 24-CCCR 0990, case of style, the state of Texas versus Nadia Joe Rubin. Ms. Rubin, your full name is Nadia Joe Rubin? Ms. Rubin, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Rubin, you may put your hand down. How are you doing, Ms. Rubin? That's good. Now, Ms. Rubin, I have before me a document that is titled Judge's Explanation of Rights Without an Attorney. Do you recognize this document?
Yeah.
At the top of this document, there's a set of initials above the line that's on the line that states, I want to reset my case to hire my own attorney.
Yeah.
Did you place your initials on this line?
Yes, sir.
At the bottom of this document, there's a signature on the line that is titled Defendant. Is this your signature?
Yes,
Ms. Rubin, before you sign and initial this document, did you read the document?
yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Rubin, I read your answers. Based on your answers, your case is going to be reset, give you an opportunity to hire your attorney. Please have a seat in that first chair on the wall. Next case is cause number 24-CCCR 1130. And this case is styled as State of Texas versus Margot A. Prudhomme. Ms. Prudhomme? How far you setting it out?
September 18th.
Okay, we just set them out 30 days. Yeah. Miss Prudhomme,
Hello.
how you doing? Your full name is Margot A. Prudhomme?
Yes, sir.
Okay, Ms. Prudhomme, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Ms. Prudhomme, do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes.
Okay, I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Now, Ms. Prudham, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Ms. Margot, Prudham, just have a seat where you're sitting and one of the prosecutors is going to come out and talk to you about your case.
Okay, thank you. That's it. You can just. I can bring it to you.
Next case is cause number 24 CC Ciara 0942. Case is styled the state of Texas versus DeAndre Dwayne Marshall. Mr. Marshall, your full name is DeAndre Dwayne Marshall. Mr. Marshall, would you please raise your right hand? Mr. Marshall, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you gonna say yes or no?
Yes, sir.
Okay. Now, Mr. Marshall, you put your hand down. How are you doing? Doing good? Now, Mr. Marshall, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
No.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
Okay, I also have a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Okay, now, Mr. Marshall, before you signed and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Marshall, I read your answers. You can go back and have a seat where you were sitting, and one of the prosecutors is going to come out and talk to you about your case. Next case is cause number 24 CCCR 1126, Kellen Dion Gilder. Mr. Gilder, your full name is Kellen Dion Gilder?
Yes, sir.
Mr. Gilder, would you please raise your right hand? Mr. Gilder, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Gilder, you may put your hand down. How are you doing, Mr. Gilder? I'm doing fine, thanks for asking. Mr. Gilder, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to have your case, that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Gilder, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay. Mr. Gilder, you can go back and have a seat where you were sitting, and one of the prosecutors will come out and talk to you about your case. Next two cases are cause numbers 24 CCCR 0958 and cause number 24 CCCR 0959. Both cases are styled the state of Texas versus Aaron White. Mr. White, would you please come forward? Mr. White, your full name is Aaron White
Yes, sir.
or Aaron Scott White?
Aaron Scott White.
Okay, Mr. White, would you please raise your right hand? Mr. White, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Son of God.
Mr. White, you may put your hand down. How are you doing, Mr. White?
Pretty good. How about you?
I'm doing all right. Thanks for asking, Mr. White. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding the trial. Do you recognize this document?
Yes, sir.
Now, Mr. White, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And it's everything in these documents true and correct to the best of your knowledge.
To the best of my knowledge.
Okay, Mr. White, you can have a seat where you were sitting and one of the prosecutors will come out and talk to you about your case. Next case is cause number 24CCCR 0960. Both the case is styled the state of Texas versus Nolan Martin White. Mr. White, your full name is Nolan Martin White.
Yes, sir.
Mr. White, would you please raise your right hand? Mr. White, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. White, you may put your hand down. How are you doing, Mr. White?
Good.
That's good. Mr. White, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that's titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes,
Mr. White, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. White, I aware of your answers. You can have a seat and one of the prosecutors will come out and talk to you about your case.
Sorry, who was he?
Nolan White.
Thank you.
Okay. Next case is cause number M324616, case of style state of Texas versus Jeffrey Don Inns Jr. Mr. Inns, your full name is Jeffrey Don Inns Jr. Mr. Inns, would you please raise your right hand? Mr. Inns, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Inns, how are you doing? That's good. I'm doing fine. Thanks for asking. Mr. Inns, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorneys? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Sure.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Mr. Inns, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Inns, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will give information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. And once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. We're gonna need Miss Jennifer Raji. Yeah. Yeah.
Even though those are debating, I don't think that would be the case. Otherwise, it's up to you.
Okay. Next case is, cause number 24 CCCR 1432. Case is styled the state of Texas versus Damon Watkins. Mr. Watkins, your full name is Damon Keith Watkins.
Yes, sir.
Mr. Watkins, would you please raise your right hand? Mr. Watkins, do you swear, affirm, and tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Watkins, you may put your hand down. How are you doing, Mr. Watkins?
All right, like you.
I'm doing fine, thanks for asking. Mr. Watkins, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Watkins, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Watkins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information, but before she gives you that information, the bailiff is going to give you some bond conditions that I need to go over with you. Mr. Watkins, the bailiff has just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document,
Yes, sir.
that title now? This document states as follows: following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
No, sir, I don't.
Okay, basically means that you can't break the law while you're out on bond.
Oh,
In
yeah.
this state, any other state, or even a federal offense. You understand that?
Yes, sir, I do.
Okay, now, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yeah, I do.
Now, condition number 3 does not apply. Condition number 4 does not apply because this is not a DWI case. However, condition number, hold on a minute. This is a DWI, isn't it? Yeah, this is a DWI case. So condition number 4 does apply. And condition number 4 states that a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code. Now, the offense that you're charged with is listed under that section because this is your offense is a DWI second.
Yeah, I'm be honest with you, I'm not gonna do none of this. Like,
Okay,
I don't even do drugs, I don't drink, so I feel like I shouldn't even be going through this.
Okay.
or whatever, you know?
these are conditions of bond. Let me tell you this here. You violate the conditions of bond, you're gonna be arrested and placed in the Jefferson County Jail because these are the conditions of your release.
Okay, so how long did I need to stay in jail for?
Well, I don't know that. Okay, these are the conditions of your release. Okay. Okay, so that's the choice you want to make. If you want to go to jail, you can do that. Okay,
No, I mean, what I have to do is so it won't be on my record. I mean, they can drug screen me or give me.
No, listen, you see, it's okay. You went from 0 to 100.
Yeah, I mean,
These are conditions of your bond. This is saying that, one, you can't commit an offense against the laws of this state, any other state, or
Okay.
against the United States. That's one. Now, if you saying, I'm gonna go out there and break the law, well,
okay,
you need to be in jail then.
yeah, I understand what you're saying, okay.
Okay, so this is saying that if you violate these conditions, you can be placed, your bond can be revoked. We can kick you off a bond and put you in jail for violating these conditions.
Yeah, okay.
You understand what I'm saying?
Mhm.
Now, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. So if the court says, well, we're gonna, you need to take a drug test, the court hadn't said that. But if the court says that at sometime later on, if you refuse to take the test, you can be placed in the county jail because that's a violation of your conditions of your bond. Or if you take the test and refuse and fail the test, then your bond can be revoked. You understand what I'm saying?
I
This,
mean, they should have told me about it when I had a bond, when I had bonded out, they ain't tell me about nothing about this.
I know, I'm telling you
Okay,
now,
okay.
because the judge set the conditions of the bond,
Okay,
okay?
you telling me now, okay.
Yeah,
Okay,
they should have told you something, but now, 3 does not apply. Now, 2, number 3, well, 2 doesn't, well, number 4 does apply. 3 doesn't apply because 3 only applies like if you had a family violence case. Your case is not a family violence, so you don't have to worry about that. But 4 does apply because you have a DWI second, and that is called a subsequent offense listed under section 49.04 through 4906 of the penal code, okay? And I'm gonna just read it to you, and if you have any questions, then we can talk about it.
okay.
It says a defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verifications of such installation being submitted to the court on or before 3 days after the day. Okay, so that's saying that if you have a vehicle or if you drive a vehicle, that vehicle needs to have an interlock device on it.
And I gotta pay for it.
If you drive in the vehicle or if you own a vehicle, you can't drive a vehicle unless it has that interlock device on it. Okay. That's what that statement means. That condition. And this is a condition that we give in all cases where a person is charged with a second DWI or a third or fourth or whatever. Okay, this is a condition that we have on all our bonds for a person who is charged with a second DWI or more. Your case is a second DWI. Okay, do you understand that?
Yeah, I understand.
All right. Now, number 5, defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. So if a person, if you have an interlock device and
You would still have the.
you get ready to get in the vehicle, you're blowing it and you're above the limit, that's a violation. You understand what I'm saying? So you can't get in a vehicle that doesn't have this interlock device.
Where you going, Noah?
Now, number 6, the defendant must attend AANA meetings 3 times a week and provide proof to the court. Okay? And there are places in this area, we got a laundry list of places, I'll just give it to you, where you can do AANA meetings.
If the opportunity.
and there's a list that, that they'll sign, a sponsor will sign verifying that you,
I don't understand why I gotta go to AA meeting.
that's a condition of your release.
But what? I don't even drink.
Okay,
Don't drink.
okay, good. I mean, it's just AA, well, it's good, it's AA meetings, that's a condition of your release.
No, just the offer on the table at this point, I'll leave the.
Okay.
You don't want to have it.
I don't know if it's AA, it's not just for drinking. Okay,
I don't understand it. Why they
it's for
got-
drugs as well.
I'm going through this. I don't drink and I don't do drugs.
Oh, well, I don't
got no
know.
problem with, you know, popping up and taking a drug test or alcohol
Only thing I
test,
know is,
whatever.
only thing I know right now, you charged with your second DWI.
But I thought it's into proving to guilty.
I said you're
Innocent.
charged with, I didn't say convicted. Listen to what I said. I said you're charged with your second DWI. I didn't say you was convicted of your
But I
second
mean, I
DWI.
gotta pay for all these things that I shouldn't even have to if I don't.
AANA is free.
Yeah, but they want me to put an interlock on my vehicle, which I gotta travel and go places. And
Okay,
in
well,
and
you
out of
can't
town.
drive a vehicle without an interlock. Okay,
Crazy.
okay. The court has a responsibility to make sure that the public is safe. Public is not safe with an individual.
I wasn't even driving though.
Let me do this here before you go any further. You have a right against, you have a Fifth Amendment right against self-incrimination. Anything that you say can and will be used against you in a court of law, you have a right to have an attorney. If you cannot afford one, an attorney will be appointed to represent you. And in this case, you have been appointed an attorney to represent you. So you can have your attorney present during any questioning. Okay? So those are the conditions of the bond. Now, if you violate any one of those conditions, your bond can be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You will be arrested and placed in the Jefferson County Jail. You understand? All right. Okay, you can have a seat in that first chair on the wall. Did we see if Jennifer is back?
She wasn't at her desk.
Okay, let's see if she's there now. Kevin Ross. That's on the, this is, you need to spell it, M-O. You can sit right, stand right there.
Which one? Which word?
That's in the, one of the conditions of probation. Okay, this is cause number 24 CCCR 1158, case of Styles of State of Texas versus Kevin Ross. Mr. Ross, let's see. Your full name is Kevin D. Ross? Demond?
Yes.
How you doing, Mr. Ross?
Good.
That's good, Mr. Ross. Would you please raise your right hand? Mr. Ross, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Ross, you may put your hand down. Mr. Ross, I have before me a document that is titled Jefferson County, that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Ross, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Ross, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a, but I say now, Mr. Ross, before she gives you that information, I need to give you some bond conditions. Mr. Ross, you can step over here and get your bond conditions. Now, Mr. Ross, you see that document that's titled Standard Bond Conditions in County Code at Law Number 2?
Yes, sir.
And I'm going to go over this document, which is states as follows. Following the return of information in County Code at Law Number 2 of Jefferson County, Texas, all bonds executed for release in this case are ordered subject to the additional following conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol, and the defendant may revoke the bond, and the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply, and condition number 4 does not apply because this is not a DWI case. However, condition number 5 does apply, and condition number 5 states the defendant will obtain and participate in the Spindletop 8 TAR program, which stands for Addiction Treatment and Recovery Program. Do you understand that condition?
Yes.
And condition number 6, you remain drug and alcohol free. You understand that condition?
Yes, sir.
And condition number 7, you will participate in the ASAP program with Spindletop Center, 2750 South 8th Street, Building C, Beaumont, Texas, 77701. Do you understand that?
Yes, sir.
Now, if you violate any one of these conditions, Mr. Ross, your bond can be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail.
Yes,
Okay.
sir.
So you'll get in contact with the folks at Spindletop to get started on that program. Now, you're gonna have a seat in that 3rd chair on the wall and wait for your name to be called. Did Miss Jennifer?
Oh, you were with somebody, that's why.
Okay, you can tell her we're ready.
Yeah.
Jose T. Tiki. TK? A, okay. Okay, Mr. I'm gonna give you these documents. Mr. TK, it's my understanding that he speaks Spanish. We have Ms. Jennifer Raji, who is our interpreter. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear to interpret Spanish to English and English to Spanish, so help you God?
Yes, Judge.
Mr. Raji, you may put your hand down. Mr. Raji, ask Mr. Teak if his full name is Jose C. Teak or TK.
Su nombre completo es José Piqué.
Jose Toribio Tica.
Okay,
Yes, Judge.
and ask Mr. TK how he's doing.
¿Cómo está?
Bien.
You doing good? Now, ask Mr. TK if he recognized that first document on that's before him.
Sí, te acuerdas ese documento que está enfrente de usted.
Okay.
Sí, te acuerdas firmando ese documento que está aquí.
Sí.
It's,
And ask him if that's his signature on the line that is titled defendant.
está como, sí, esa es su firma aquí. Yes.
And ask him if those are his initials on the line that state he'd like to apply for court-appointed attorney.
Esas sociales diciendo que quieres aplicar para un abogado.
Sí.
Yes.
Okay, now you could turn the next page over. There's another document that titled Affidavit of Indigence. Ask him if he recognized that document.
Tú puedes llenar ese documento.
Este.
Sí,
Okay.
tú puedes llenar eso.
Sí.
Yes.
Okay, and turn to the next page. There should be a signature above the line that is titled Defendant's Signature in Spanish. Should at the top left-hand side. Ask him if that's his signature.
¿Ese es su firma completo ahí?
Sí.
Yes.
Okay. Now, ask Mr. TK if before he signed and initialed those documents, if you went over those documents with him in Spanish.
Firmar y llenar estos documentos, sí, que es todo en español.
Sí.
Yes,
and matter of fact, the documents are in Spanish, is that correct?
yes, Judge.
And ask him if he read and understand everything in those documents.
Diciendo que usted lee y entiende todo que está en los documentos.
Sí.
Yes,
And ask him, if everything in that document, in those documents are true and correct to the best of his knowledge.
y que esos documentos son de verdad. Yes,
Okay? You can tell, Mr. Takei that I read his answers. And based on his answers, he meet the eligibility requirements for the appointment of a court-appointed attorney. His attorney is Charles Rojas.
okay. Dice que se lee todos sus respuestas y si le van a apuntar un abogado de la corte y se llama el abogado Charlie Rosas. Y él, sí, sí.
And,
La información y él también habla español.
you can tell him that Mr. Rojas will contact him. And, Mr. Rojas will be given information to contact him. And he will also be given information to contact Mr. Rojas.
Toda la información de lo que puedes contactarlo y también al abogado de usted.
Okay? You
Okay.
can stand over there, get,
Y ellos le van a dar
that information and tell him they have a blessed day.
y dice el juez que tenga un día.
You are.
He said,
You
the
are.
same to you, Judge.
All right, thank you. Well, um, okay, Mr. Gilder, you initially stated that you wanted to waive your right to an attorney and represent yourself. Is that correct? And you rejected the state's offer. Is that correct? Now, at this point, you have three options. You can represent yourself. You can ask for a court-appointed attorney. You can apply for a court-appointed attorney, or you can ask that your case be reset to hire your own attorney. Okay. Now, do you know what you want to do? You still want to represent yourself? Okay, so what we're gonna do, we're going to reset your case. Okay, this is Kaylin. Okay, we're gonna reset your case, for an announcement. That'll be another court date from today. Okay, and, could you hand this document, clerk?
Yes, Judge.
Before, your case is reset, I need to give you some bond conditions. And the bond condition states as follows. Standard bond conditions in County Court at Law Number 2. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds to execute release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? And condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and a test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 does not apply. Condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? You cannot, while you're on bond, you're prohibited from possessing a firearm or ammunition. Do you understand that? Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed. It should be in Spanish. Is there some paperwork on there?
I don't remember giving it back to you.
I don't see it down here.
I don't,
What did he say?
he has it in his hand.
He wants to go for a second. He wants to.
Yeah.
We just get
Okay. Okay, so Mr. Gilder, just
Judge,
have a seat. Huh?
I think we need to take a step back.
Wait.
Like, there seems to be.
You already talked to him, didn't
Okay,
Yeah.
so he wants to know if you.
you? She already talked to him.
Later.
He denied, he didn't want the,
I know,
he didn't accept the
He
plea.
don't want
I know.
to miss.
He's
or-
back here.
Right,
I'm
yeah.
trying to figure out why.
So he said he wanted to take it to trial.
I know.
Get an attorney.
There's steps for that.
Yeah, I know.
Right.
He said he want to represent himself to get there. That's what, so we resetting this case.
That's not, I don't think
I
that.
talked to him. I don't know who you talked to.
Well, no, Judge, he's,
Now, let me ask you, okay, let me ask you this, hold on, just settle down. What do you want to do? Okay, and you want to go to trial? Okay, that's what the paperwork reflect. Okay, so just have a seat. I mean, that's not gonna be today. So what's gonna happen is, no trial is gonna happen today, because think about it. They can't just pick up the phone and call witnesses to come down here and call, for us to order a jury trial, you're gonna be put on a schedule. Okay, and so the other thing is you'll have an opportunity to have discovery. Discovery means that you'll have an opportunity to have access to the evidence that the state has against you. You're gonna set up an appointment with the district attorney's office, and they're gonna allow you to have access where you can go in and review all of the evidence that the state has, so that you can get prepared for trial. You understand that?
He'll only be able to view the materials there.
Yeah.
Judge.
But he can't have actual possession.
He can, I say he can have access.
I just wanted to make sure,
Yeah, you're not giving him anything. Yeah, he's just gonna have access to the evidence that the state has.
I was just informed something that's separate. Can I pull him to the side and speak with him real quick?
Okay, y'all can go back and talk. Okay, hold on a minute.
So he came out.
Okay, now what do you? Nolan White?
Yes.
on the air mode, I'm not exactly sure what option he wants.
I'll find out.
That's better for him. That'll give him time to do
Okay, now, Mr. White, you rejected state offer, is that correct?
Yes, sir.
Now, at this point, you can do one of three things. You can, request that an attorney be appointed to represent you, or you can request that you be given time to hire an attorney, or you can continue to represent yourself. Okay, so what do you want to do? Okay. Okay, now, Mr. White, I have before me a document that is titled Affidavit of Indigence. I will show this to you in a few seconds. Okay, now, Mr. White, let me do this here. You will have to, you have scratched out a bunch of stuff. On this document here, you're gonna have to put your initials on the third line. You can scratch out this here, down here, okay? Did you hand this to him? You get, he has a pen. If he doesn't, I have one. Hmm? You did what?
Oh, okay.
Those are from Mr. Gilliard.
You said on the third line?
Yeah, but yeah, you see what you had, your initials on the fifth line, you gotta scratch through that.
Okay.
And then you're gonna put them on the third line again, like where you had it the first time. I think it was the first time, or was it the second time?
That was the first time.
Okay. Okay, Mr. Hubel, could you hand that document back to me?
Yes, sir.
Thank you. Now, Mr. White, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
Also, I have a document that is titled Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. White, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Correct.
Okay, Mr. White, I read your answers. Let's see who's next. Okay, Mr. White, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, Mr. White, just in the research, you'll be free to go.
Thank you.
Okay, once you get that information from the court coordinator, you'll be free to go. You know what? You said you gonna be in school, right?
Yes, sir.
You might need to set this at a time when he's not
Yes, I was gonna ask you.
in school. Okay, let's do this. This is Mr. Nolan White.
Okay, which one? I wanted to represent.
Well, he changed his mind.
Oh, that's Mr. White?
Yeah,
Yes,
Okay.
well, both of them had at one point, but they changed their mind.
Okay.
Okay, so, Mr. White, what we're gonna do, let me do this here. Now, I need.
Yes, sir.
Earlier you said you wanted to waive your right to attorney and represent yourself. You've talked to the prosecutor, is that correct?
Mhm.
And you rejected the offer, and now do you want to change your mind about representing yourself?
Well, I had a counter offer and I guess that they're not gonna take that.
And I don't know if you want to know any.
Nah, I don't need I don't need to know any details of your communication with the district attorney. I don't need to, because I don't get involved in the plea
It's just
bargaining
not what the
agreement.
state's offering at this time.
Yeah, I know, you rejected that offer. So at this point, you can do one of three things. One, you can continue to represent yourself.
Mhm.
Two, you can ask your case to be reset to hire your attorney. Or three, you can request that an attorney be appointed to represent you.
Let's reset. And, let me talk to some attorneys.
Good, okay. So let me do this here. Before I allow you to, I need to give you this paperwork back. So you hand this back to him. You're gonna have to scratch through the bottom where it stated that you wanted to waive your right to attorney and represent yourself. And then you're gonna put your initials on the top line that states that you want to have your case reset to hire your own attorney.
Okay.
Okay? Okay, you can hand that back to him. Okay. So your case is going to be reset, Mr. White. Our court coordinator is going to reset your case. Once she resets your case, you'll be free to go. Well, you have two cases. Yeah, once you reset your cases, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. You're welcome. Here you go. And I think you need this too. Oh, no, Gilder? You need Mr. Gilder?
Yes.
This is what he had at first. This is,
It was like how many times?
that's what he had. He said it was a waiver and, so does he need the, like an affidavit of indigence?
I thought yes.
Yeah, he didn't, wait up. Did he fill one? I don't think he filled one out. Yeah. Okay, Ms. Cruden, initially you said you wanted to waive your right to attorney and represent yourself. Is that correct?
Yeah.
And you talked to the prosecutor? Is that
Yes.
correct?
Yes.
And the prosecution made you an offer and you rejected that offer. Is that correct? Now, you have three options. You can still proceed by representing yourself, or you can ask that your case be reset to give you time to hire an attorney, or three, you can apply for a court-appointed attorney. So that's what you want to do. Now, you had already filled out an affidavit of indigence. Well, you didn't quite fill it all the way out, but I'm going to give you this second page back, and I'm gonna highlight the box that you need to fill out in yellow.
I'm gonna trade you, Judge.
That's what she needs to fill out.
Mr. Gilder's petition.
Okay. Oh, he needs to keep that. Oh, yeah, he needs to keep his bond.
He's coming
petition.
back up, so I
Yeah.
don't know if you still needed him. You want me to hand him to him?
Yeah. Okay, now, Phillips County Court of Law back. Number 2 is back in session and clause number 24 CCPR 1130. Case is filed in the state of Texas versus Margot Prudhomme. And Ms. Prudhomme, is that your full name?
Yes,
Now, Ms. Prudhomme, you was previously sworn in, is that correct?
correct.
Now, Ms. Prudhomme, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled
Yes.
defendant? Or are these your initials on the line that state you'd
Yes.
like to apply for court appointed attorney? I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
yes,
On page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature?
yes, it is.
Ms. Prudhomme, before you signed and initialed these documents, did you read the documents?
Yes,
Did you understand what you read?
yes,
And is everything in these documents true and correct
true,
to the best of your knowledge?
yes,
Ms. Prudhomme, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you. And you will also be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
thank you.
You're welcome. Mr. Kalen Gilder. Mr. Gilder, your full name is Kalen Gilder.
Yes, sir.
Is that Kalen D. Gilder?
Yes, sir.
Mr. Gilder, you were previously sworn in, is that correct?
Yes.
Okay. Now, Mr. Gilder, let me get this. What? This is one page. What are the other 2 pages?
It's been on my clipboard.
It's an affidavit. The only thing, they have 3 pages, but they have a judge's explanation, a waiver, and it's here. You get one, take a look at it.
I don't know what a clipboard. The rest of the stuff should be on the
Here's a
clipboard.
clipboard right here.
No. From his other stuff.
From what other stuff?
He had more.
Big when first go out.
When he originally filled out. This is- What are we doing? What, right. So is that one.
Not in here. Was it up here?
So we need to
Oh,
fill
let's
out.
see. Might be up here. It's white. That's Prudence. He didn't fill it out the first time. Why would we
He did,
have?
he filled it out. So what is it that we're? So he need the oath, right?
That's page 2, yeah.
Right.
And then
And
the
then this
order,
is, so that's it, just the oath.
and the order. Yeah, I mean, yeah, I'm gonna need all 3. Let me see.
Yeah, just those two, right? We didn't need the waiver.
Jefferson County Court at Law number 2 is back in session. The court is in session. In cause number 24 CCCR 0942. The case is styled the state of Texas versus DeAndre Dwayne Marshall. Mr. Marshall, is that your full name? Mr. Marshall, would you please raise your right hand? Mr. Marshall, do you swear and affirm to tell the truth, the whole truth, and nothing but the truth to help God?
Yes, sir.
Mr. Marshall, you may put your hand down. How are you doing, Mr. Marshall?
Good.
You doing good? That's good. Now, Mr. Marshall, I have before me a document on my computer. This document is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, DeAndre Dwayne Marshall, on or about March 13th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Marshall, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Marshall, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest. Now, Mr. Marshall, are you pleading no contest freely and voluntarily?
Yes, sir.
Okay. Now, Mr. Marshall, are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Now, if you're fighting the charges, you're saying, I'm in a plea of not guilty and I want a trial, I'm fighting the charges.
Basically, if you had wanted to go with the agreement that we had made, you would go with either the choice of guilty or no contest. And in this case, you've chosen no contest, meaning that you don't want to dispute.
Now, let me do this here. Now, Mr. Marshall, the choice that you make as to how you're gonna plead, your choice, okay? So, we're not trying to get you to plead one way or another. I'm just trying to get an understanding of how you want to plead. If you want to plead not guilty, that's fine, no problem. If you want to plead guilty, that's fine, no problem. If you want to plead no contest, that's fine, no problem. But whatever you plead, I just need to make sure that you understand what you are pleading, what it means. You understand what I'm saying?
Yes, sir.
Okay, okay. So, the three options that you have is if you plead not guilty, you're telling the court that you did not commit the offense that you have been charged with. Do you understand that?
Yes.
If you plead guilty, you're telling the court that you committed the offense that you have been charged with. Do you understand that?
Yes.
Or if you plead no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. Do you understand that?
Yes.
Okay. Now, let me ask you this. Do you know how you want to plead?
No contest.
You want to plead no contest? All right. Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not want to fight or contest the charges? Yes? All right. Now, Mr. Marshall, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State Exhibit number 1. Mr. Marshall, do you recognize this document? Let me show you on page 2. On page 2, there are two sets of initials. One set of initials here and the other set of initials there. Do you recognize this document?
Yes, sir.
Okay. Now, the first set of initials is the lower paragraph that is titled waiver, and it is next to a line that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On the next set of initials is the lower paragraph that is titled discovery admonishment. And it is the initials are on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
Now, on page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature? On the next document, that is titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes.
Now, at the top of this document, there are 2 boxes that's checked. The first box that is checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you are giving up your right to an appeal. Do you understand that statement?
Yes.
Okay. Now, before you sign and initial these documents, now let me ask you this here before I go any further. Do you understand what an appeal is? I think I mentioned it to you earlier. For example, if you think you've been wrongfully convicted or this court committed an error by convicting you, you would like a higher court to review your case because you felt that you've been wrongfully convicted or this court committed an error by convicting you. Okay. That and the higher court is right above us on the ninth court of on the 3rd floor. It's called the Ninth Court of Appeals. They review appeals, and so if the court, as I mentioned to you earlier during arraignment, if the court follows this plea bargain agreement, and if you want to appeal your case, you have to get permission from me to appeal your case. Do you understand that?
Yes.
Okay. Now, on this document is saying that on the first line, that this is a plea bargain case. In essence, you and the state have reached a plea bargain agreement to settle your case. And you have no right to appeal. Do you understand that?
Yes.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
So by entering into this plea bargain, you cannot appeal the case if you decide later on that you wanted to appeal your case. Do you understand that?
Yes.
All right. I just wanted to make sure you understood that. Now, before you sign and initial all of these documents that I just showed you, did you review the documents?
Yes, sir.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Now, Mr. Marshall, are you a citizen of the United States?
Yes, sir.
All right.
This time stay after states 1.
Now, the state is offering states exhibit number 1 to be used as evidence in your case. States exhibit number 1 is the first document that I showed you on this laptop, right? On this tablet. This is the same document that have your initials in the 2 locations that you identified as being your initials. And this is the same document that has your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? And when I say evidence, what's in this document, it says that it's just saying that this is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is confinement in jail for a term not to exceed 1 year. That's just the range of punishment for a Class A misdemeanor. And or a fine not to exceed $4,000, or a person could be given both such fine and confinement for a Class A misdemeanor. Do you understand the range of punishment for a Class A misdemeanor? All right. Now, this document also states that, let's see, this is a plea bargain case, and the court is not bound or limited by any punishment recommendations made by the state. So the judge don't have to follow this plea bargain agreement. If a plea bargain does exist, the court must inform you in open court whether or not it will follow the agreement before any finding is made on your plea. Do you understand that?
Good.
Should the court reject your plea bargain agreement, you are then entitled to withdraw your plea. Do you understand that?
Good.
Now, the next paragraph talks about permission to appeal. If the punishment excess does not exceed the plea bargain agreement, the court must give you permission before you can appeal on any matter, in this case, except matters raised by written motions before trial. Do you understand that?
Yeah.
Now, citizenship, you say you are a U.S. citizen, is that correct? And you also, you have a right to have an attorney and the right to be represented by an attorney. Okay, it says that you have a right to have an attorney to represent you if you are determined to be indigent. An attorney will be appointed to represent you. Do you understand that?
Yes.
And now this talks about deferred adjudicated probation. I mentioned to you there were two types of probation: unadjudicated probation and adjudicated probation. This talks about unadjudicated probation, which is called deferred probation. It's the same thing. All right, and it says that if the court defers adjudicating you guilt and places you on community supervision is probation. On any violation or any condition, you may be arrested and detained as provided by law. You are entitled to a hearing limited to the determination by the court of whether to proceed with an adjudication of guilt on the original charge. No appeal may be taken from this determination. After adjudication of guilt, all proceedings, including assessment of punishment, pronouncement of sentence, and granting of probation, and your right to appeal continues as if you have not been deferred. If you subsequently receive discharge or dismissal from deferred adjudication, you may have the right to petition the court for an order of non-disclosure in accordance with the provisions of and conditions of section 411.081 of the Texas Government Code. If eligible for an order of non-disclosure, the earliest possible date you may be eligible to file the petition is on the second anniversary of the order of dismissal. Now, it all depends. Now, what they say here is that one, you won't have a conviction on your record if you successfully complete probation. And if you successfully complete probation, you can ask for a non-disclosure where your record, as I mentioned to you earlier, will be sealed. Okay. Now they're saying that the earliest possible time you can get it is the second anniversary date, which is 2 years. That's not the case for all situations, because the government code 411.072 and 411.0725 gives times when a person can actually be eligible to apply for a non-disclosure. But you can talk to an attorney about that. Do you understand that?
Mm-hmm.
Okay. Now, notice of judicial clemency. Now, I mentioned that to you earlier. If a person successfully completes the probationary period, 1, and if there's no more time left on the probation, 2, and 3, if they're successfully discharged, they can ask the court for judicial clemency, whereby a conviction will not be on their record. Okay. Now, that's in the discretion It's not mandatory. The court can or the court may or may not do it. That's the judge's discretion. But you can apply and the judge may grant it or may not grant it. Do you understand that? Now, what judicial clemency is where you won't have this conviction on your record, and it won't be on your record. And if you get another case later on, a subsequent case, as I mentioned on arraignment, then the case can be brought back up. You can have this on your record. Okay. Do you understand that?
Yes,
Okay, and if you try to get a license with CPS, they can deny giving you a license, or they can revoke or suspend any license that you have. Now, the second part of this document talks about waivers. These are things that you are giving up, and I'm gonna explain that to you. And it reads as follows. After being duly admonished, that's of the nature and charges against, after you've been told what you've been charged with, in this case, evading arrest and detention, and all your rights and consequences of entering a plea of guilty or nolo contendere, which means no contest. I hereby state in open court, I understand the foregoing admonishments from the court, so you understand what I told you thus far.
yes,
And I am aware of the consequences of my plea. What are the consequences? Where you'll be placed on probation, deferred adjudicated probation. You understand that?
yes,
Now, I am mentally competent and my plea is freely and voluntarily made. You saying that you're not mentally ill, you don't have no mental condition that affect your ability to understand or what you're doing today and the consequences of entering a plea of no contest in this case. Is that right? Now, I have been advised this day by the court of my right to representation by counsel. The court has informed me that you have a right to have an attorney. If you can't afford to have an attorney, one can be appointed to represent you. Do you understand that?
yes, ma'am.
Understanding my right to have counsel appointed to me free of charge if I'm found to be indigent, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I specifically waive my right to be represented by an attorney, to consult with an attorney before I give up these enumerated rights. It is my decision to represent myself, and I do so knowing the dangers and disadvantages of self-representation. Now, we talked about that on the judge's explanation of rights to defendants without an attorney. I said there are dangers and disadvantages of self-representation. Representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Do you understand that?
Yes,
Okay. Then I further elect not to request appointment of counsel and waive the 10 days notice before disposing of this case. Now, what that means is 10 days notice, you have a right to have 10 days. If the state wanted to go to trial on this case, they have to give you 10 days notice. They can't just send you to trial today. Do you understand that?
yes,
Because you have a right to 10 days notice. I give up my right to a jury, so you don't want to have a jury trial. You want to dispose of this case today. Give up my right to a jury trial in the case and my right to appearance, confrontation, and cross-examination witness. So by not having a trial, you won't have any witnesses coming in here,
yes, ma'am.
testifying on the witness stand. I consent to any oral and written stipulation and agree that they may be considered in my case. The stipulation was State's Exhibit number 1 that had your initials on page 2 and your signature on page 3. And you said it was all right for the state to use that as an exhibit. Is that correct?
Yes.
Okay. Okay. I consent to any oral or written stipulation and agree that it may be considered as evidence in my case. All rights given to me by law, whether form, substance, or procedure. I give up my written stipulation. I give up my written stipulation and agree that they may be considered in this case. After being admonished as to the nature and charges against me of all the rights and the consequences of entering a plea of guilty or nolo contendere. I do hereby state that I have read the charging instrument, whether it be an information, motion to revoke / adjudicate, and the court has explained it to me. And I explained to you what you've been charged with. I stated that I have before me an information that alleges that on or about March 13th of 2024, while you was in Jefferson County, Texas, that you committed the Class A misdemeanor offense of Class A misdemeanor offense of evading arrest detention.
Yes,
Okay, you understand that? And you said I explained to me and I committed each and every element alleged. I further asked the court to accept my plea and waive from jury and enter a judgment and proceed against me according to the law without further delay. I hereby enter a plea of nolo contendere in this case. You understand that?
yes, sir.
Okay, now, state his office, state Stephen one, you don't have no objections to that. And you are a citizen of the United States, is that correct?
Yes, sir.
And you are mentally competent to stand trial, is that correct? Okay, now do you have any mental conditions?
No, sir.
You're not, okay. Now, the court is gonna find, well, first of all, the court is gonna accept your plea of no contest. The court will find that you are mentally competent to stand trial. The court will also find that your plea and waivers were freely and voluntarily given. The court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is that agreement?
That agreement is to 15 months deferred probation with a $500 fine, 6 years community service, and the requirement that the defendant attend and complete the moral recognition therapy class.
What's let's say community service, how much?
60, Your Honor.
60? And moral recognition,
That's correct.
what is this court cost?
270.
277. We don't have an affidavit here, so, 277. I think this is 900, 224, 15. Let me do this, is 77. 915.
That's not in the file.
Okay. 40. Okay, now, Mr. Marshall, the state is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $500 for sport costs of $277. You'll be required to pay a probation fee of $60 a month, reimbursement fee of $15 a month, your analysis fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $137 a month. Are you able to pay the $137 a month?
Yes, sir.
Okay. And you will be required to perform 60 hours of community service. And you'll be required to attend and complete the moral recognition class, as well as the other standard terms and conditions of probation. Now, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
Do you accept the state's offer?
I,
Okay, now, Mr. Marshall, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Marshall, if you successfully complete the probationary period, this case will be dismissed. It will not result in a conviction on your record, and you will be eligible for a non-disclosure. Now, before I do that, I also have these other two documents that we actually went over before we even started. This is the this is the judge's explanation of rights to defendants without an attorney. Now, you acknowledged that this was your signature and your initials on this document. Is that correct?
Yes.
And this is a waiver of counsel for purposes of entering a guilty plea or proceeding in the trial. And previously, you acknowledged that this was your signature on this document. Is that correct? And you previously acknowledged that you read and understood everything in these documents. And everything in these documents is true and correct to the best of your knowledge. All right. Now, Mr. Marshall, you're gonna stand next to the bailiffs and follow her directions. Once you follow her direction, you'll be free to go, and you have a blessed day. All right. And when you finish that, you can come back up. Now, he has somebody here with him.
His mom.
And okay, you have your mother here with you?
Yes, sir.
Now, Mr. Marshall, you can come back on up. Now, Mr. Marshall, I noticed that your mom sit through this whole proceeding with you. She took off from work. Okay, to be here with you. Now, your mom told me what your age is. I'm not gonna announce what your age is, but you're a whole lot younger than I am. Okay. And so a lot of people, young people always say that, you know, they have friends and stuff, and their friends is their ride or die, they had their back. And whenever they down and out, they'll be, you know, they'll be there for them. And I've been in this business a long time. And I hear a lot of people say that, but I don't see the same thing what they say. It doesn't match. And what I mean by that is, I don't see none of your friends here today. Okay, you ride or die. They're not here today. The ones who got your back not here today. You know why? Because everybody's not your friend and everybody's not your partner. But I can tell you this one thing: when that lady right there says she got you, she got you. Because that's your ride or die. Okay, that's your friend. The one lady who's been putting a roof over your head, clothes on your back, and food on the table. All right. But you know what? You're fortunate that you have somebody like that. A lot of people don't have nobody like that. They come down here, they don't have nobody. But you got somebody. Okay? That's a blessing. Okay? You need to thank God for that. That you got that young lady right there by your side. Okay? And she's here with you, she's hanging in there with you. All right. So what happened here today does not define who you are. In essence, your present situation is not your permanent destination. Okay. You got a lot of years to live. Okay. You know, at one time I had hair on my head. I don't have it now. You know, where you going? She's already been, I've already been. We're looking through the rearview mirror. Right? And so just keep on living. Whatever you want to do in life, don't give up on your dreams. Okay. This is not what you did today doesn't end your dream. In fact, you can use this. This is not a stumbling block. This is a stepping stone. And you know what a stepping stone is, huh? You ever seen somebody with a ladder? What it makes them do when they get on, they go up the ladder. They go up higher and higher. You can go up higher, okay? So whatever your dreams are, pursue your dreams, okay? This is gonna just put this behind you. Do what you need to do, reinvent yourself, and make that lady right there proud of you, okay? Make her proud of you, and you can do that. I believe that. You can do that, okay? So, like I say, if you successfully complete this here, this, you can get your record, you can get a non-disclosure on this here, all right? So you have a blessed day. Hang in there. Don't give up. Hang on, don't hang up. All right? All right. Thanks for coming down here with your son. All right. Yeah, we got Mr. Gilder.
No,
Why don't you come on up? What is? He want a court appointed attorney, huh? Yeah, he put his initials on the
Does he need to fix it?
wrong line. Got to put it on the one that's above that.
What?
She
It's
is
supposed to be the
a-
third line, not the fourth line.
No.
It's the third line. Now, if she misses some money from work, you need to pay her that money.
Why?
restitution amount.
Yeah. Okay, now, Mr. Okay, this is clause number 24 CCCR 1126, case of style of state of Texas versus Kalen Gilder. Mr. Gilder, is that your full name?
Yes, sir.
How are you doing, Mr. Gilder?
Good.
I'm doing fine. Now, Mr. Gilder, you was previously sworn in. I have before me 3 documents. We're going to go over these documents with you. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yeah.
And are these your initials on the line stating you would like to apply for court appointed attorney?
Yes, sir.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant. Is this your signature? Okay, Mr. Gilder, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Gilder, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Peter Doyle. Attorney Doyle will be given information to contact you. And you will be given information to contact him. The court coordinator will give you that information. Once she gives you that information, Mr. Gilder, you'll be free to go. You have a blessed day. Now, Mr. Gilder, we gave you some bond conditions earlier. Is that correct? Did I go over those bond conditions with you? Okay. You need to make sure that you abide by those bond conditions. Now, Mr. Gilder, I see that you have someone here with you as well. Who's that?
Pops.
Your pops.
Pops, you wanna come up here, Pops?
Sure.
We not coming to talk.
He said I could.
I'm just.
Oh, well,
Hurt today.
you say moral support. I bet you did. You've been more than a moral support during your life, during his
Well,
lifetime.
I'm sorry, Your Honor, with all due respect, I was his pop's lawyer, but, I decided I couldn't do it like that.
No, you can't do it like that. No. Now, sir, what's your name?
Gerald Gilbert.
How you doing, Mr.
I'm
Gilder?
doing well, yourself.
I'm doing fine. Now, I see that you're here with your son. That's a good thing. Many times we have people come here, they don't have nobody. But you're here supporting them, continuing to support them. This is not your first time supporting them. You're supporting them all his life. And you're still here with him. And that's a good thing. Like I told that other young man, some people don't have nobody, but you have somebody, that's a blessing. Okay, that's a big blessing. That man right there, he's standing here with you and he's supporting you. You his son, and he's gonna continue to support him, but make him proud. Okay, just make him proud because He's gonna be there for you. He's been there for you. He's gonna always be there for you. And not only that, but he's an example of what kind of man you should be for your children. Okay? And that's one who is a loving, supportive parent. Okay? But this process, you have a lawyer. You can talk to your lawyer about your case. And as you navigate through this criminal justice system, okay? And then one day you're gonna put this behind you as well. And like I told that other young man, you know, don't give up on your dreams. This is not a dream ender. This doesn't break anybody's hopes. Okay, it doesn't shatter any. It's just like a bump in the road. Okay, just put this behind you and continue to pursue whatever dreams that you have, and you'll be able to get there.
And I know no one's in here right now, but had he been earlier, you know, and I'd be here, I would say the same thing. You gave that other guy some instructions on don't let this, you know, bring him down. Back when I was 18, I never told him this to the day I was arrested.
Mm-hmm.
And I got deferred adjudication.
Mm-hmm.
I got my waiver and I did 17 years in the military.
Wow.
In the Navy.
Wow.
So I know for a fact that, you know, you can overcome.
Right. So you hear that? Yeah. Don't let it get you down. I mean, you know, yeah, you good. Just hang in there. Just be tough. I always tell people, hang on, don't hang up. Just keep going. All right. So your case is going to be reset by a court coordinator. Once your case is reset, you're free to go. You have a blessed day. Make sure you get in contact with your lawyer. All right. Nice seeing you, sir.
Yes, sir.
And this will. Okay, Russell. No, he was on Zoom. Russell Bean was on Zoom. Is that Romero Rodriguez? Cause numbers M333742 and cause number M333744. Both cases are styled the state of Texas versus Romero Rodriguez. Romero Rodriguez was scheduled to be in court this morning for the arraignment docket at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Romero Rodriguez. Romero Rodriguez did not answer. He has not appeared in court since the court has been in session. The time now is 1:18 p.m. on today's date of July 23rd, 2024. Ms. Bailiff, would you please call the name of Romero Rodriguez at the courthouse door?
Yes, sir. Romero Rodriguez. Notify.
Okay, Romero Rodriguez's name was just called at the courthouse door. Romero Rodriguez did not answer. A reasonable time has passed to give Mr. Rodriguez an opportunity to appear in court. It's not appearing in court. State, do you have a motion?
State moves for bond forfeiture.
Those motions will be granted. Romero Rodriguez bonds will be forfeited. And a warrant should be issued for his arrest in cause number M333742 and cause number M333744. Next case is cause number 24CCCR0998. Case is styled the state of Texas versus Carlos Roman Tejada. Carlos Tejada was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Carlos Tejada at the courthouse door. Carlos Tejada did not answer. Carlos Tejada has not appeared in court since the court had been in session. The time now is 1:19 p.m. on today's date of July 23rd of 2024. Ms. Bailiff, would you please call the name of Carlos Tejada at the courthouse door?
Carlos Tejada. Carlos Tejada. Notify, John.
Carlos Tejada's name was just called at the courthouse door. Carlos Tejada has not answered. A reasonable time has passed to give Mr. Tejada an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Carlos Tejada's bond will be forfeited and a warrant shall be issued for his arrest in cause number 24CCCR0998. And this will conclude the calling of the court's of the court's docket on today's date of July 23rd, 2024. In County Court at Law number 2, Jefferson County, Texas, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused.
Thank you, Judge.
All right, you're welcome.